Alter ego and joint partner trusts. An alter ego trust and a joint partner trust are different from other trusts in that they allow a person, the settlor, who is 65 years or older, to transfer assets into a trust without triggering a taxable gain on the assets being transferred. This type of trust also is not subject to the 21-year deemed disposition rule that deems that most trusts dispose of assets for tax purposes every 21 years. The only allowed beneficiary of an alter ego trust is the settlor during their lifetime and their spouse for joint partner trust. All income in the trust will be attributed back to the settlor and will appear on their tax return on an annual basis. On the death of the settlor and the last to die of the spouse for joint partner trust, there will be a deemed disposition of assets for tax purposes. Any type of capital property such as real estate and non-registered investments can be transferred into these trusts. Registered investments such as RRSPs and tax-free savings accounts cannot be transferred into these trusts. Advantages of these trusts are probate fee savings. Assets transferred to the trust do not form part of the estate and are therefore not included in the calculation of probate fees. Depending on the value of the estate and the provincial jurisdiction, this can be a significant amount. Ease of administration of estate. Avoiding the probate process minimizes the disruption of management of the assets and administration costs. Protection from estate litigation. Several Canadian provinces have legislation that allows children and spouses to challenge a will. Having the assets pass through a trust will largely avoid this issue. Privacy and confidentiality. Unlike a probated will that becomes a public document and discloses estate intentions and asset values, a trust is a private document. Incapacity planning. A backup trustee rather than a power of attorney may be a more effective way to manage assets in the event of incapacity. Disadvantages, costs. There are fees to set up and to maintain the trust. Charitable donation. There must be some discretion provided to the trustees for the charitable gift so that a charitable tax receipt can be received. Cannot utilize small business capital gains exemption on shares in the trust. A solution can be to trigger a gain and take advantage of the capital gains deduction when transferring shares into the trust. For someone with the right circumstances, alter ego and joint partner trust can provide significant planning advantages. To learn more, feel free to email me at rob@covenant.ca.